morning. Welcome to the First District Court of Appeals. We have 4 cases on the docket this morning. We will be taking a 5-minute recess in between the second and third cases. When I call your case, please stand and state your name and your readiness to proceed. The first case on the docket this morning is C-240436 in Re AR.
Good morning, Your Honors. Margaret Kane, ready to proceed.
Good morning, Norbert Wessels, on behalf of the state, ready to proceed.
Thank you. The second case is C-240520, Marshall versus Mercy Health Anderson Hospital.
Good morning, Your Honor. Curtis Scrivener on behalf of the appellants, and yes, I'm ready to proceed.
Good morning, Your Honor. Jessica Brett on behalf of the appellees, Mercy Health Anderson Hospital and Boston First Mercy Health, and we are ready to proceed.
Thank you. The third case on the docket this morning is C-240437, State of Ohio versus Sean Donovan.
Good morning, Your Honor. William Gallagher on behalf of Mr. Donovan. I'm ready to proceed.
Phil Cummings for the state, Your Honor, ready to proceed.
Thank you. And the last case is C-240461, State of Ohio versus Kyron Thomas.
And Judge Stephanie Kessler on behalf of the appellant, ready to proceed.
Norbert Wessels, once again, on behalf of the state, ready to proceed.
All right, thank you very much. The first case again is C-240436 in Re AR. Ms. Kane, you may come forward when you're ready. Would you like to reserve time for rebuttal?
Yes, 3 minutes, please.
Can you proceed?
All right, thank you, Your Honors. May it please the court. To support an adjudication for receiving stolen property, the state must prove beyond a reasonable doubt that the accused received, retained, or disposed of property of another, and that the accused knew or had reason to believe the property was stolen. The central issue at stake in this case is whether, when construed in a light most favorable to the state, the evidence was sufficient to establish beyond a reasonable doubt that AR received or retained the property in question within the meaning of RC 2913.51. The clear answer is no. The terms receive and retain are not specifically defined under this provision. Accordingly, these terms have to be given their common or plain usage. Receive means to take possession or delivery of, receive means to take possession or delivery of, while retain means to hold or to continue to hold in possession. In other words, both terms denote possession. So when determining whether or not somebody has received or retained property, the question is whether or not they have constructively or actually possessed that property. When it comes to a case involving a stolen vehicle, as in this situation, the answer is clear when the person who has been accused of RSP was the driver. In that situation, the driver will almost always be considered to have actual possession of the vehicle.
Was there any theory of liability in this case that AR was the driver, or was it conceded by the state that at most he was a passenger?
There's no theory in this case that AR was the driver. All parties agreed that at most he was a passenger in this vehicle. There are some questions about whether or not he was even in the vehicle, but for purposes of this part of the argument, even if the court accepts that the state's proposition that he was in fact in the vehicle, there is no evidence to support that he received or retained the vehicle within the meaning of this provision.
So is it your position that we should set aside any part of the legal test that would deal with driving a stolen car and focus solely on the
Yes.
other part of the test?
Yes, Your Honor. And so the sole question here is whether or not, as a passenger in a vehicle, there was sufficient evidence to support a finding that AR received or retained the property. This court in Ray Bromfield helped settle some historical questions around when a passenger in a vehicle may be found guilty of receiving stolen property. And the test that was set forth, or the explanation that this court kind of came to after reviewing all of the case law from different districts, was that a passenger in a vehicle may be found guilty of receiving stolen property if the evidence shows beyond a reasonable doubt that the passenger the evidence must establish beyond a reasonable doubt that the passenger constructively possessed the vehicle. And so constructively possessed means that they either were in the vehicle for some amount of time after learning it was stolen, or that the passenger participated in the theft of the vehicle. In this case, there's not evidence of either of those things.
So, is it your position that the people who were at the church and who heard the crash and came out and saw 3 people running from the northern lateral, which is not a road that you just walk on, 3 people running from that, including AR, that's not at all evidence that he was not only in the car, but that he shouldn't have been in the car?
So,
Following up with that, and then when the witness asked, do you need any help, the 3 of them took off running.
so I'll take that in parts.
Okay.
So the first part is whether or not that could be construed as circumstantial evidence that those 3 youths who were running in the vicinity of this vehicle were occupants in the vehicle. For argument's sake, even if we accept that, yes, that is sufficient circumstantial evidence to support an inference that those 3 youths running from the vehicle were, in fact, the occupants of that vehicle, we still haven't dealt with whether or not AR, as a passenger in it, if we assume that, had received or retained that property. And so there are a number of cases that have addressed this issue and considered various fact patterns in which they have determined there's sufficient evidence to find that a passenger was, in fact, in a position where they received or retained. And
Doesn't the case law counsel say that a passenger receives or retains a stolen vehicle if they're using it for their personal transportation or their personal enjoyment? And in this case, the car had to get from some other location to the Norwood Lateral. So can't we make an inference, or couldn't the trial court have made an inference that AR was being transported in the car?
so the case law does indicate that one of the ways is for transportation or entertainment. But again, that's knowing that the vehicle is stolen. They used it for transportation or entertainment. The cases that have dealt with that have had additional evidence to support that inference. So merely being in the vehicle, merely being in a stolen vehicle is not enough to establish that a passenger received and retained it.
But we don't have merely being in the vehicle wrecked. So vehicles don't wreck in a stationary situation, the vehicle wrecked in motion. So that's transportation, right?
So I think the question is whether or not there's enough evidence to prove that AR used the vehicle for transportation. And the reason I'm emphasizing that so much is use comes with it a connotation of purpose. And so intentionally got into the vehicle, knowing at the time that he got into the vehicle that it was stolen, and then proceeded to continue riding in it. So there's case law that talks about duration of time being indicative of whether or not somebody was using it for transportation or for entertainment. So you have in Ray Bromfield, where the passenger had remained in the vehicle for an hour. That was established through evidence, and where it was clear that they knew it was stolen and they could have terminated their association with the crime, but didn't. And similarly, in Ray Windle had a passenger who had been in the vehicle for 5 hours and failed to terminate his association with the crime. Other cases that deal with use for entertainment purposes or for transportation, there's been additional evidence. For example, the passenger indicating, hey, yes, I knew the vehicle, to police, admitting, yes, I knew the vehicle was stolen. Yes, I remained in the vehicle. We were just riding around, having fun. And that was sort of the fact pattern that existed in Ray Bickley. Other cases have shown that it was used to transport a person for the purpose of going to buy alcohol. And in that case, that was used for entertainment or transportation. The problem in this case is the only piece of evidence that remotely connects AR to this vehicle was one witness's testimony that sometime after the crash, and it's not entirely clear in the record, for example, how long after hearing the crash he went out and was able to observe it. It's not clear how far from the church where he was at his drama rehearsal, how far that was from the overpass where he was able to actually observe the crashed vehicle. And so Mr. Miller's testimony is, yes, I heard the crash. I left my drama rehearsal at the church. I went to the overpass and I saw a crashed vehicle and I saw 3 youths running from that vehicle. That is the only piece of evidence that connects AR to the vehicle. So there's nothing about when he may have gotten into the vehicle. There's nothing about his relationship to the other youths. There's no physical evidence.
So are you asking us to place a time frame? As you know, they have to be in the car for 10 minutes to an hour before we find that they have used the vehicle? Because, I mean, Bromfield and the other case that you just spoke about, the 5-hour case, they didn't say anything about, less than that would be insufficient. It's just they said the time. But in this case, I mean, it is clear that he was in the car from the time of the crash to at least, you don't just turn onto the Norwood Lateral. I mean, you have to get off of an exit to get on there. So, I mean, it's not like, Main Street where you can just, get in a car and drive and then immediately crash.
So I would say that there's no evidence about where exactly on the Norwood Lateral, where the exit was in the record. So I think you raise a fair point that might be distinct from a situation where somebody's getting into a car on a residential street and then it crashes. However, that's not in the record. It's not clear where they got on. There's no evidence about how long they were in the vehicle. And I'm not asking this court to draw a bright line rule. What I am indicating is that unlike most other cases, there is absolutely no evidence about what preceded that moment when the car crashed.
Well, counsel, we know that the car was taken from the apartment complex, right?
Yes.
But we don't know when exactly.
Right.
And we also, I think, don't know where the apartment complex is located. Is that consistent with your review of the record?
Yes, so we don't know exactly where the apartment complex is located. However, it's clear from the record that it's actually in a different police jurisdiction, which at least can be inferred from the officer needing to call over to the district of residence in order to make contact with the registered owner of the vehicle. And so, from the record, we know that sometime between October 28th and October 30th, when the accident happened, the vehicle was stolen, but we don't know when, we don't know who. And so, in some cases, so for example, in State v. Johnson, which is a case that was cited in the state's brief, there was some suggestion that the defendant and the co-defendant may have been involved in the theft of the vehicle. And while there wasn't an exact timeline of how long they had been in the vehicle, there was at least some testimony indicating, an amount of time had elapsed since the defendant left his home, and that came from his mother's testimony. And then there was also testimony that the co-defendant had a screwdriver and gloves in his pocket. And from that, the appellate court in that case said that it was reasonable for the jury to draw an inference that the appellant, the defendant, may have participated in the theft of the vehicle. And that case was also involved fleeing the vehicle where police were in pursuit, which is another distinction between.
Your time has expired.
Oh, thank you very much. I'll reserve the remainder of my time. Thank you.
Thank you.
Thank you, and may it please the court, opposing counsel. Unless there are any particular question that this court wants addressed off the bat, I'd like to start with a quote from this court's decision in Ray Bromfield so we understand the legal position of where we're at. Where a passenger used the stolen vehicle for transportation or for his own personal entertainment, the passenger received and retained that vehicle. And so for the purposes of determining whether or not the AR in this case received or retained, we're dealing with the use and whether that use was done with the knowledge that the vehicle was stolen or whether he
And
should
to
have.
clarify, the state is not contending that he was at all the driver.
No, I think that I guess the record suggests that he could have been the driver, but I don't think it was ever argued by the state that we had enough information to suggest that he was definitely the driver. I think what the record demonstrates is that at a minimum, he was in the car, and thereby we're using passenger kind of as that like minimum standard as opposed to, but I guess to the state's position is it doesn't matter whether he was the driver or a passenger. I think the evidence is sufficient to convict him or to adjudicate him delinquent based on what we
This
have.
Bromfield test speaks to two different actions that can satisfy the retain or receive piece of the statute by a passenger. One is transportation and one is entertainment. Does the state have a perspective as to which of those or both?
I think it was in this case, I think it was for transportation. I think there's a fact pattern that could exist where perhaps it's called joyriding. If the teens did not intend to actually go into a location but were whipping donuts around a McDonald's parking lot, that might be not for transportation, but is still using the vehicle as is contemplated by the statute.
Where would the evidence show that AR was transporting himself from?
I think some of it. I think the evidence has to be inferred through the circumstantial evidence that was presented in this case, as this court has pointed out already. A car does not crash just sitting stationary. Certainly not on a public roadway. The evidence I think suggests, although through inference, through circumstantial evidence, that the car was traveling, got into a single car wreck. And that all of these individuals were in the car. And so thereby the trier of fact has to make an inference that it was being used for transportation. Obviously, there is no direct testimony as to that fact, but that is not as what's required and certainly is not an issue for this court, at least as for a sufficiency of the evidence standard. I think a reasonable trier of fact can come to the conclusion that the car was taken from one location and somehow made it into this new location with all of these individuals in it, that it was being used for transportation.
Does it matter that we don't really seem to know exactly where they were going?
I do not think so, no. I think to the extent that we have to demonstrate that it was being used for transportation, I think the record is sufficient to establish that. Frankly, that's what a vehicle is mainly used for transporting individuals from one location to another.
Is there any case law or any statutes that would define this transportation concept for us? I mean, when I think of the plain meaning of that word, I think of going from point A to point B, but is there something that would challenge my notion of that or expand it?
I don't think there's any definition that appears in the Ohio Revised Code for, at least not in the criminal context for this statute. I do not think so. There might be other definitions of transportation under, say, the traffic code, but I think it would, I'm only presuming here, but I think it would fall pretty closely in line with the plain understanding of that term, which is, like you said, getting from one point to another. And so in that sense, I think that's what was happening here.
What about the knowledge element? Can you address that?
So in regards to whether or not the individual knew that the vehicle was stolen, I think there are two main sets of facts that point to that knowledge. Both of them, again, relying on circumstantial evidence. One of them being that the back window was crashed in and that the steering column was stripped, which the officer testified at trial was indicative of the vehicle being stolen. That's an inference that I think the court can make. And another.
Can I ask a clarifying question before you go
Yeah.
on? With the back window, I noticed a couple places in the transcript, I think it was the officer possibly talking about the window being covered by some film or something.
I think that's correct.
And then it sounded like, although I don't think this was perfectly clear, that the fact that there was a film over it was indicative of it being stolen. Can you explain that? Because I didn't really understand what he was talking about.
At least in terms of the question before this court, I think the understanding is that it appeared as though the back window was broken and it had been covered up in some way. So I think the indication is that it was not caused by the car wreck. Because the car accident possibly could have broken the window. But when we're looking at the individual who enters a car, specifically, I think I drew the distinction between this case and the case State v. Sims, which was cited by opposing counsel. If I'm an individual and I'm getting in a car and I see a back window that's broken, I see a steering wheel that has been stripped, I see that the individual, let's say that AR was not driving the vehicle, but I see the operator plug in a USB device and start it that way instead of starting it with the keys or something. That would go towards my knowledge that the vehicle, at that point I should reasonably understand that the vehicle that I'm in is stolen. Those are all indicators that the vehicle was stolen.
Okay, I didn't totally understand the cover on the window, but I do now, so thank you.
In the second, so that's one aspect that goes to the knowledge aspect. The other aspect would be him running away, both from, not only from the scene of the accident, but once he was confronted by the witnesses who said, hey, you were in this car wreck, you just had gotten that car wreck, do you need help or anything? And they say bolt, and they all run away from the individuals. The Ohio Supreme Court has said that fleeing is consciousness of guilt and therefore evidence of guilt, and I think this court can make that same, or the trial court
It
can
doesn't
make.
have to be,
Correct.
right? It just, the trial court was permitted to make that inference.
Correct. I mean,
So, a clarifying question on that too. All the case law that I saw for that concept talked about fleeing from law enforcement, and Mr. Miller was not law enforcement. So does that make a difference?
I don't think to the extent that one can draw an inference that they're trying to escape culpability for something that they did wrong. I think here the facts specifically support that inference, because in this situation the witness approached directly indicated, hey, you guys just came from that car that you crashed over there. Are you okay? And it's at that point that one of them says bolt. I think the inference is very clearly drawn that they were doing something illegal. They tried to play it off by going away from the car scene. They were implicated in the illegal thing that they did, and in order to escape punishment for that, they ran away. So I don't think it matters that the running away there was from a witness, because that witness had directly implicated in something that, again, he knew that he should not have been doing. I think all of that is a fact that points to that he knew that the vehicle was stolen at that point.
Did the witness actually see the crash?
No.
And how far was the witness from the location where he saw the
I don't
individuals?
know that I can give you feet or inches or miles or anything like that from the record. What I do think the record establishes is that the witness's testimony was that he immediately heard the crash, and so immediately went outside to investigate, and upon going outside to investigate, looked over and saw them going from the side of the crash. So I think at least through inference, one can presume that it was not very, very far away.
So
as
were they like scampering up the outside of the lateral?
I'd have to look back at I believe they were coming up what would essentially be a ramp. I think there was, if I'm not mistaken, I believe the record indicates that there was some sort of bridge or overlook down to where that was, and they were coming from that area. But I'd have to go back and review the record to be sure. But they were coming from that public roadway onto the area at least close to the area where the church was located. I think that record indicates that this all happened over a short course of time. So I think the inference there is that it did happen not very far away. Again, all inferences that I think are supported by circumstantial evidence, which has no less value than direct evidence, all inferences that the trial court was reasonable in making because, again, all of the evidence points to the understanding and the conclusion that the trial court came to, which is that this individual, AR, was a passenger of this stolen vehicle. He knew it was a stolen vehicle. After crashing, they were, maybe not accosted is the right word, but approached by a witness who implicated them, and then they ran from the scene. I think opposing counsel had said several times that there's no evidence of this, and I think what you can tell from my argument is it's not that there was no evidence, it's that the court was able to and made inferences based on the facts that were in the record to come to the conclusion that it came to. The walking away from a vehicle is not no evidence of being in that vehicle. It's circumstantial evidence that they were being from the vehicle. And when you take all of the evidence together, especially when you take it in the light most favorable to the state, I think you come to the conclusion that the trial court came to. I want to push back on something that was said by opposing counsel, that AR was merely in the vicinity of the vehicle. I believe that the witness's testimony multiple times, what the evidence suggests is that they were coming directly from the vehicle, which I believe I've spoken about already. Unless the court has any more specific questions. I don't believe I have anything else.
All right, thank you.
Thank you.
Thank you. So I just want to hit a couple of clarifying points. First, regarding no evidence, I was referring to what happened preceding this incident, which I think is really important in this case. So one thing that opposing counsel had talked about is transportation going from point A to point B, and that it doesn't really matter where or when or how. And to a certain extent, that may be right, but the problem is that that portion of it requires that the accused knew that they were using a vehicle that was stolen for transportation. In this case, we don't have enough evidence to establish that at the time that AR allegedly got into this vehicle, he was aware it was stolen.
So-
Now, we can have, pardon.
So, okay. As far as the fact that the steering wheel had been stripped, they didn't use keys to start the car, and the window had been knocked out and covered, could we not infer from that
So
that he knew?
I think we can infer that once he was in the vehicle, he would have realized it was stolen. But I don't think we can infer that at the moment he got into the vehicle, he was aware of it. So what I'm trying to get at is we are drawing a lot of inferences. And it's getting to a point where it is a stacking of inferences to come to the conclusion that this youth retained and received this vehicle. He is a young man who entered a vehicle as a passenger, arguably.
And can you address the impact of the flight? So it's been argued that there's an inference that could be made, and perhaps there are competing inferences that could be made as to why he ran, both from the scene of the car crash and then the scene of the interaction with the witness. But if we have competing inferences, why are we not at a situation that results in an adjudication?
So if we have, in this case, I think that if this court draws all inferences in favor of the state, they could draw an inference properly that at the time he exited the vehicle, he knew that it was stolen and ran. I think there are certainly other inferences that could be drawn, but the question isn't just about at the time he exited the vehicle, did he have reason to be concerned about getting in trouble? And again, this wasn't police. He was running from a citizen, not law enforcement. And so the other thing is that the vehicle crashed, the kids exited, and the witness spoke to one of his comrades, and the comrade said bolt. So there's also a possibility that he was just sort of following along what his friends were doing. But I think the biggest point that I want to emphasize is that there just simply isn't enough about the circumstances, about how he initially came in contact with the car. There's no testimony or no admissions made by AR. There's no testimony from other youths in the vehicle to suggest that he had any control in this situation. He did not constructively possess this vehicle. At least that was not established by the evidence that was presented. And so we would ask that this court reverse his adjudication and discharge him from further prosecution.
Thank you.
Thank you, Your Honors.
Thank you for both of your arguments this morning. We will take the matter under submission and issue a timely written decision. The second case on our docket this morning is C-24-0520, Marshall versus Mercy Health Anderson.
Apologize for the cotton.
Take your time. Would you like to reserve time for rebuttal?
Yes, Your Honor, 3 minutes, please.
All right.
Just so I'm clear, are you going to give me, you're going to give me the hook at, you're going to give me the signal at
I
12,
will give you a
please?
signal, yes.
Thank you very much.
And there are also lights that will illuminate,
Okay.
or should illuminate.
Okay, thank you very much, I appreciate it. Good morning, and may it please the court, Your Honors, counsel. I'm Curtis Fiffner on behalf of the appellant Linda Marshall. Ohio law has never required the shotgunning and overnaming of every single potentially negligent employee solely to hold their employers accountable for their actions, unless it is a situation that involves a legal malpractice case against a lawyer or a medical malpractice case against a doctor. Since neither of those situations are present here, this court should reverse the trial court and remand it for 3 reasons. First, the application of Claussen that we're seeking from this court this morning is not only supported by 14 other appellate and trial courts, but is also the exact application of Claussen that the healthcare entities asked for in their amicus brief in Claussen. Second, Ohio law has always recognized that plaintiffs have the ability to sue the master, the servant, or both pursuant to Lucido and 100 years of precedent. And third, the application that's been proposed by Mercy Health would not only produce absurd real-life consequences for all Ohio employees, it would also require this court to engage in significant judicial activism and undo about a century of Ohio precedent, but also disregard Ohio Revised Code 2307.24, which says that these entities are all supposed to be treated as one entity for purposes of vicarious liability. Now, you're the only opinion that matters to me. Do you have a preference on where I start? Okay. All right, I'll move to my first point then.
Actually, before you start,
Yes, Your
I
Honor.
do have a question.
Yes, Your Honor.
It seems to me that a very important issue here is who can be liable for malpractice. Can you address that, please?
Yeah, you're absolutely correct, and that's exactly where I was going to go with my first point.
Thank you.
Because the Ohio Supreme Court has always taken the position that there is a very narrow view of who can commit malpractice, and that is doctors and lawyers. That was said in Lombard versus Good Samaritan. It was said in Richardson versus Doe. It was said in Worth versus National Union, and it was said in Claussen as well. It's always been limited to the situation of doctors and lawyers, and then there's very, very good rationale for that.
Counsel, is there some conceivable argument, playing this forward, that by extension applies to employees under the supervision of doctors and lawyers? So for example, like paralegals or PT assistants or people like this?
No, Your Honor, because again, we have duties and we have tasks, and nurses can only operate within their scope of practice. The same way that lawyers and doctors are responsible for our paralegals, doctors are responsible for their nurses. So no, there isn't a situation where a nurse should be able to commit malpractice. And they're very clear in their brief. They're not saying that a nurse should practice medicine or that a nurse should be able to commit malpractice. They're simply asking that Clausen be extended to all non-physicians. And that's simply not what the Ohio Supreme Court has ever said, and what no appellate court that has ever decided Worth has ever said. And so,
Is malpractice defined
Yes, Your
anywhere?
Honor. Yes. So malpractice is, so it was specifically stated in Worth, and it dealt with professional misconduct, okay? And then, again, they limit it to the common law understanding of it that was in that is still in 2305.11, and then was later put into 2305.113 as it pertains to doctors and lawyers.
2305.11 is,
That is the malpractice statute. That's malpractice in general.
is it malpractice statute of limitations?
It is a malpractice statute of
And then
limitations
it
as well.
defines a medical claim?
The medical claim statute is 2305.113.
But in that, it includes non-physicians.
Correct. And that's why what you've seen in the courts that have decided the application of Clausen, but also in the application of Worth as it pertains to non-physicians, is the differentiation between a medical claim against a nurse and a malpractice claim against a physician. Because while nurses can be amenable to medical claims, they don't commit malpractice like doctors do.
But the statute of limitations for the nurse is still 1 year?
Yes, sir.
So doesn't that seem like the medical claim is almost part of malpractice, at least as defined for the statute of limitations?
It's as part, it's subject to the same 1 year statute of limitations, but a medical claim is not medical malpractice, as has always been traditionally recognized by the Ohio Supreme Court and this court and every single court that has ever used the definition of malpractice as it pertains to nurses.
And you were going to tell us the rationale for why
Sure.
malpractice was accepted from the general rule. What was the rationale?
Because what the second district said in Stanley was, physicians and attorneys are professionals who are generally hired to perform services for their clientele as independent contractors. Physicians and attorneys are not typically considered employees at their respective businesses.
So it's their status as a non-employee?
It's that combined with what the Ohio Supreme Court said in Lombard. And specifically in Lombard, this is a 1982 case, they said a nurse, although obviously skilled and well-trained, is not in the same category as a physician who is required to exercise his independent judgment on matters which may mean the difference between life and death. A nurse is not permitted to exercise judgment in diagnosing or treating symptoms. In the same way that I, as a lawyer, have to use my independent judgment when I'm trying cases, when I'm up here in front of the firing squad, that's separate and apart from how a paralegal operates.
I think the crux of the question is, there are plenty of professions, right? There's
Yes.
cosmetology
Yes.
and, nursing and all kinds of things that are licensed professions with
Yes.
standards that people must meet in order to practice them. But for reasons that I think we're trying to hone in on, Ohio law has separated out lawyers and doctors and called claims against those practicing professionals malpractice. Why is that?
It's simply because of the unique circumstances of our profession, where we can't be bound by the same policies and procedures and guidelines as nurses. The hospital controls nurses. My law firm doesn't control my actions. The hospital doesn't control the doctor's actions the same way that they do the nurses, which is why when you see,
Is that because the doctors are simply non-employees?
it can be, but again, what Clausen made clear is that the rule of law applies to employee physicians, non-employee physicians, part owner physicians. It applies to all physicians because they can commit malpractice.
And malpractice, as they were talking about it back then, was just the common law malpractice.
Correct.
And that kind of by default had always just applied to professional doctors and lawyers.
Correct. Because
And no one else.
Correct, because we practice law and doctors practice medicine. Nurses don't practice medicine. Nurses practice nursing, which is a lower scope of practice, a more confined area of practice. And that's why I think it's so important when this court decided the Meehan case in 2012, they said, the medical claims alleging the negligence of a hospital employee such as a nurse are governed by the doctrine of respondeat superior. Under that doctrine, a plaintiff may elect to sue only the employer or both the employer and the employee. But therefore, even without the nurse as a defendant, the plaintiff may still maintain a lawsuit against the employer for the alleged negligence of the nursing staff. And again, this court followed what Cope said in the 2nd District. And Cope, I thought, addressed this really, really well. And they said, a hospital employs a wide range of people who provide a variety of medical service to patients. The hospital is in exclusive control of hiring criteria, training, and routine performance evaluation and review. A hospital should be responsible for the negligence of its employees who perform medical services and act in the scope of their employment. To allow a hospital to be shielded from the rule of respondeat superior liability due to a court's liberal application of the distinction carved out by Worth would effectively allow the distinction to swallow the rule. And that's what we're talking about here. We're talking about the situation where it's the reason that it's always been limited and why these people are subject is because there isn't the level of control. And the issue then is if you broaden it and you take it beyond what has always been narrow, and that's what Worth stressed, the narrowness of their decision.
Well, so can a hospital practice nursing then?
Well, I would argue it this way. It depends on how we want to look at things, right? Because when we're saying a hospital cannot commit malpractice, what we're talking about is that the doctor commits malpractice. The hospital doesn't. But contrary to what their appellate brief is arguing, where they're saying that's just the cetus of treatment, if we're going to go down that route, that means there can never, ever be respondeat superior or vicarious liability if you don't sue every single potentially negligent employee, because no corporation ever does anything other than exist and have First Amendment rights.
Do you think that the exception that they're arguing, logically, if what they're saying is true, that would apply to almost any situation where you were, like, typically you would sue the employer and not name the employee, like a convenience store where there was a slip and fall, you'd have to sue the employee who failed to clean up the spill or whatever?
Yes, Your Honor. If we're going to take this outside of the malpractice context, it means that in every single case, you have to sue every single potentially negligent employee. And not only is that problematic from the standpoint of, okay, fine, what if every employee that we've sued now elects to have their own personal counsel? You know, we can't rent out the Fifth Third Center to have trials in Hamilton County. So the question is, what do we do in that situation? And the biggest issue is that if you take this logic to that level, that you have to sue every single potentially negligent employee, what it means is that if we miss somebody in that situation where somebody slips and falls at Walmart, that means that contrary to what 2307-24 says, which is that in a vicarious liability situation, the principal and the agent are to be treated as one entity, we could potentially have situations where in the cases that we've seen where there's like nursing home cases and multiple people over multiple times, not only could they start apportioning fault to their own employees, but getting a reduction in their liability because we sued 7 and not the 8th nurse. And they can then say, well, it was actually the 8th nurse that was responsible for all this, so we should, that nurse was 50% responsible, so we should get a 50% reduction because you didn't name and sue that 8th nurse. And again, that's directly contrary to what 2307-24 says. They're supposed to be one entity. And that's why it's always been recognized under Ohio law that everybody below the line of doctor and lawyer does not need to be named and sued for purposes of respondeat superior and vicarious liability. We simply have to prove that there was direction and control by a greater entity over those people.
And your time has expired.
Thank you, Your Honor. I
Thank
appreciate
you
it.
very much.
Sorry. May it please the court. Simply put, the issue before this court is not just whether or not nurses can commit malpractice, but rather whether Clausen applies to allegations, to cases in which the allegation is nursing negligence, and hold the hospital vicariously liable where that nurse has never been named as a party. I submit to you that the Supreme Court has decided that, in fact, that the nurse or the employee does need to be named in order to
Where
hold the
has
hospital
the
vicariously.
Ohio Supreme Court said that?
The Ohio Supreme Court specifically said that they're not limiting this to a professional practice exception. Heights Chiropractic attempted to make that very argument that Worth carved out an exception for professional practices, i.e. Physicians, attorneys, chiropractors, things of that nature. But the Supreme Court specifically said, no, that is not what we said. What we said was there is no professional practice exception.
So under that logic, then it would be true that, like at Walmart, you'd have to sue the employee who failed to pick up the spill?
I don't know that we can apply it that far because we're looking at the context of the cases that are in front of the court. And the cases that are in front of the court are dealing with claims of medical negligence, claims of legal negligence, things like that. That's what Worth and Clausen deal with. Now,
So it's just in, like, the context of a medical claim?
I don't think that the court has answered the question as to whether or not it would apply outside of a medical claim. What the court stated was that in the context of legal malpractice claims, medical malpractice claims, medical negligence claims, this is the rule that applies, and they are not carving out that professional practice exception that so many plaintiff attorneys want to argue, that only physicians and lawyers commit malpractice. Now, it's not, the case does not turn on the use of the word malpractice, and appellant wants to accuse the appellees of ignoring that word in order to support our argument, but instead, what we believe is that the use of that word was the use of the Supreme Court, the use of the word malpractice by the Supreme Court was significant only in that was the nature of the case that was in front of it. So that's why they use the word malpractice. But I think the other language that they use, in which they specifically say that they are not carving out a professional practice exception, is much more indicative of the intent of that decision. I think this is especially important when you're looking at the claims against nursing negligence. For example, appellant argued that there is, first of all, the argument that not every court has said that every court has said that malpractice cannot be committed by a nurse.
Counsel, I think the argument that's being made, at least in the briefs, if not here in court this morning, is that following Worth, there were many decisions by appellate courts across Ohio that sort of cabined its reach to the doctor-lawyer setting and rejected the argument that you're making now. And those cases never reached the Ohio Supreme Court. They didn't accept jurisdiction over any of those cases or caution the lower courts to change course. Can you explain that landscape? I mean, why is it that the Ohio Supreme Court has not intervened in the pretty extensive body of case law that treats Worth and Clausen narrowly?
Well, while I can't speak to every case and why the court did not accept jurisdiction over those, perhaps there were other reasons why they didn't, perhaps there were other reasons why summary judgment or what have you was granted in those cases, and the court did not feel that it warranted their review. But I do think that in the Clausen case, the court addresses this and says, no, yes, you're right. Appellate courts have been applying Worth in differing ways, but this is not new law. What we're saying here, that we are not carving out a professional practice exception, is not new law. This is what we intended when we decided Worth.
I mean, if I hear you to be saying that perhaps what we should be looking at is a medical claim.
Well, I do think that it should be, at least in this instance, a medical claim. Now, whether or not that would extend further than medical claims, I can't answer that question. I think only the Supreme Court can answer that question. I am not asking this court to carve out some new law or expand.
I mean, it seems like the Clausen, it's an exception to the general rule of respondeat superior. And you're saying that that exception should go further in the context of a medical claim, but it should stop there.
No, I'm saying I don't know if it should stop there. I'm saying that for purposes of this, what we're looking at is I'm not asking this court to engage in activism. What I'm asking this court is to simply do is follow precedent, and that is the precedent that the Supreme Court set in the Clausen case. I think that.
Why would Clausen not have itself extended the doctrine to medical claims? It stopped at medical malpractice. So why would it not have extended its holding to medical claims?
Well, again, I don't think that it necessarily stopped at medical malpractice. I think it used the word malpractice because that was the nature of the claim that was before it. It was dealing with a malpractice claim. It didn't have the issue before it as to whether or not there truly should be a difference in the way that we treat medical negligence claims or medical claims or medical malpractice claims. That issue was not before.
There's a decent amount of dicta from my reading of Clausen. You know, you referenced the protracted discussion of what courts were doing with Worth and kind of the history of the whole carve out. I guess I'm just struggling, and can you help me refine the argument with respect to why Clausen, given its dicta and how, you know, it gives this sort of extensive treatment of the landscape, why it would then have been so narrow had the court intended to reach the broader application that you're arguing for today?
I guess I don't read Clausen as being so narrow. I believe that Clausen was saying that we did not intend to be as narrow as we have been interpreted as of being in the Worth case.
What are you basing that on? I'm looking at paragraph 26, where it talks about Worth not making a distinction between partners and associates. Is that where this is coming from?
I think that's part of it. I don't think that that's all of it. Again, I think that the fact that the court blatantly says we reject the notion that Worth carved out a professional practice exception is very telling. But then also the fact that they do talk about partners versus traditional employees versus associates. And I think
But
that
all of those would be attorneys who are bound by our ethics rules to exercise independent judgment.
Well, it's interesting that you bring up the issue of independent judgment because we're not talking, in my mind, I see nurses as being kind of similar to the associate situation. And that nurses are practicing not medicine per se, as it is defined for physicians, but they certainly do exercise professional judgment. They receive specialized training. They are highly trained, and in fact, it's interesting to me that appellant argues, that appellant brings up Lombard and saying that, referring to malpractice applying to physicians because physicians, the judgment of a physician may mean the difference between life and death. Yet in this case, Nurse McNeese, who is the only person that they are critical of when it comes to the vicarious liability of the hospital, and who is not named as a party, is in fact being accused of not properly exercising her professional judgment, which in the plaintiff's version of the case and version of the facts meant the difference between life and death. So they are literally accusing her of failing to use appropriate professional judgment and resulting in the death of a person, which is exactly their definition of the use of professional judgment in physicians and why this should only apply to physicians. I think it's interesting that the more recent legislation, 2307-241, while I think everyone has pretty much agreed that does not apply in this case because it was after the fact and should not be applied retroactively, I think it's important for two reasons. One is, in the first place, no matter how one tries to spin it, The language of that statute indicating in effect that nurses and other persons not specifically identified do not have to be individually sued in order to hold a hospital liable would not exist if Clausen could not truly be applied to cases involving alleged nursing negligence. Now, certainly, while we...
Why did the General Assembly pass, what's the history? Why did they do that? Did they do that simply in response to the confusion in the wake of Clausen?
I think there was more to it than that, but I do think that it was directly in response to Clausen. The timing of it is just very, very telling.
So if this was, like, if your case had happened after this law, then there'd be no argument.
Well, other than, now, I'm not going to take up my issues that I have with the law and why I think it's wrong, but certainly what the law says, which is after the fact, it does carve out this exception. But I think it's important to also note, we're so focused on this word malpractice. That statute never uses the word malpractice. I should not say that. It does say legal malpractice, but it does not use the words medical malpractice. Instead, it refers to, quote, an action upon a medical claim against a physician, podiatrist, or physical therapist. Certainly, no one can argue that a medical claim does not apply to nursing negligence, which is exactly the allegation in this case.
So somehow your case would be like the only case that would actually apply this exception, at least since Clausen, right? Like theoretically? Like this law eliminates this possibility. There are other cases since Clausen that say the Clausen exception does not extend, and your case would be like this single outlier that would somehow survive this theory of the expansion of the exception?
I don't know that it is the single outlier. The cases that I know of in the appellate departments, anyway, that deal with this would be the 8th District in Orrick, which is, I believe, a completely incorrect interpretation of the Clausen decision, in large part because it goes into great detail about doctors, hospitals not controlling physicians, but they do control nurses, but fails to recognize that hospitals employ physicians too, and
But
they can
it's
be
law.
hired and fired.
But it's law. Even though you disagree with it, it's law.
I'm sorry,
The
what?
Orrick decision is law.
It does not have, it is not precedent in this, over this court. It is in the 8th District, and this court is not required to follow that. What is precedent and what is law is the Ohio Supreme Court's rule in Clausen.
The Clausen only says malpractice. It does not say medical claims. And I understand that you are urging us to expand this to medical claims. I get that. But following Clausen means that we definitely say malpractice, but I don't see anywhere in Clausen where it specifically says this applies to medical claims as well.
It doesn't, because the claim that was before the court did not say
I understand that, but I guess I'm asking, you say that we have to follow the Ohio Supreme Court. Of course we do. But I don't see what law is requiring us to find that Clausen applies in this case.
Other than the fact that the Supreme Court specifically says that they are not carving out that professional practice exception.
It says the holding of the case is about malpractice.
In that, yes, because that was the claim before it, yes, that's true. But
it says we reject any suggestion that worth is limited to claims arising out of negligence of a partner/part owner as opposed to a traditional employee. What they were talking about, going back a little bit, as to traditional employee, were associates in a law firm who are also attorneys who are supposed to practice their independent judgment. So I'm trying to get from you, where exactly in Clausen does it say that the rule in Clausen applies to medical claims?
Clausen does not specifically say that the rule applies to medical claims.
Okay.
I personally believe that is because that's not the claim that was before it, but you are right that the court does not specifically address medical claims in the Clausen decision.
Okay.
I do note that nurses have been, and there are courts that have ruled in the McHale decision that nurses can be accused of medical malpractice. That has happened. There are other courts that have insinuated that it can happen in certain circumstances. Certainly, in this case, if we are defining malpractice as the use of professional specialized judgment, then that applies. This is a nurse who, first of all, hospital nurses in general, more so than certain other nurses, exercise professional medical judgment in supposedly, in sometimes life and death situations all the time. They are said to be the eyes and ears of the physician when the physician is not at bedside, which is the majority of the time that a patient is in there.
Counsel, I have a procedural question for you, and also it appears that the lights may not be working on the podium, so I want to, it's okay, I want to let you know that you have about a minute left.
Okay, sorry.
But you can answer my question and then wrap up. The trial court appeared to have been somewhat confused about the motion that was filed, so I noticed that you filed a motion for summary judgment, but the trial court granted motion for judgment on the pleadings. Can you explain that difference? Was there something that happened perhaps at an untranscribed hearing or something that would explain that?
There was not, and I can't explain that other than I believe that it was just a mistake in the way that it was titled. But certainly the motion was for summary judgment. The argument dealt with summary judgment, and we did not address in any sense during oral argument a motion for judgment on the pleadings.
And is there any material difference in that relief in terms of our review here?
I don't believe so, because I think ultimately it's still a de novo review. It's still, I think it's the same review for this court regardless. But as far as, I guess summary judgment does allow you to look at more than just the pleadings. And so, yes, I suppose there is a difference. Certainly the motion was for summary judgment. The decision should have been for summary judgment. And I think that was simply an error on the part of the
Just
court.
like a clerical error?
I believe it was, Your Honor.
Okay.
Yes. And I will wrap up. I understand that I'm at the end of my time. I just wanted to briefly point out to a decision in the 12th District that I alerted the court to after briefing, because it was not issued until after briefing, in which the court applied, the 12th District applied the Clausen case to a factual situation very similar to this one, in that it was a nurse who was not identified as a party defendant that the plaintiff wanted to hold the hospital vicariously liable for. In that decision, and the statute of limitations had long expired. Now, in that decision, the court does not address the issue of whether or not Clausen applies to nursing negligence or medical claims, but they do apply it for a different and interesting application of the law, and that being that the complaint itself sounded solely in malpractice, because it did not differentiate any of its claims against any of the particular defendants, just as in this case. In fact, in this case, the claims were all defendants negligently failed to use the degree of care, skill, and diligence in providing John Marshall with proper and or appropriate medical care and treatment ordinarily used by hospitals, physicians, and other medical personnel. Defendants were negligent, including by failing to promptly do tests, monitor, properly diagnose. All of these things globally say that all the defendants were guilty of this. And so in Sullivan, the complaint the complaint in this case sounds solely in medical malpractice, and there is no differentiation of allegations as to any particular party. So the derivative claims are subsumed within the context of the medical malpractice claim. And thus, even if this court is not inclined to apply Clausen to cases involving allegations of nursing negligence or medical claims, it should still apply to this case based on the rationale set forth in the Sullivan case, the Rumley case, and the White case, both of which were cited within the Sullivan case.
Great. Thank you.
Thank you.
Judge Bach, as you aptly pointed out, their position would require the Ohio Supreme Court to revisit their traditionally narrow view of what constitutes malpractice. And again, I think this is why it's so important that when the healthcare amicus groups filed their brief, they specifically said, we see no reason to upend decades of jurisprudence in extending worth beyond doctors.
Did you sue under a theory of malpractice with regard to the nurse's conduct?
I think the complaint was very, very much a standard notice pleading complaint. And I'm happy to address Sullivan specifically on that point because I think it is important. Now, even though you're going to take a break in between our hearing and the next one, I think it would take another 15 minutes for me to explain the procedural debacle that Sullivan was in, how it started, how it went up, came back, and then went up again. But the reality about Sullivan is Sullivan dealt with a situation where there was an ER provider and a physician's assistant who ordered a medication that was given by a nurse. The case didn't go to trial against the nurse. The case went to trial against the ER physician and the PA, and the jury found that they were not negligent. And so then there was an attempt to appeal to go back and try the same theory of liability against the nurse, which our entire point is that nurses follow direction. The direction and the act was already determined not to be negligent.
And wasn't Sullivan resolved on a res judicata issue?
It was exactly res judicata for that issue. The same medical act was already determined not to be negligent. So Sullivan is correct. They don't get another bite at the apple against the nurse for doing the exact same thing.
It's not really a class and case from my review.
Not at all, Your Honor. It's completely different than the situation that we have here, which is a nurse who was never sued because, again, we had the option under Lucido. And the only thing that I will leave this court with is exactly what the Second District said in Cope. A claim asserting that a nurse employee acted negligently is a type of medical claim within the meaning of 2305-113. All other medical employees are not subject to malpractice. So, thank you very much for your time this morning. I appreciate it.
Thank you. We will take the matter under submission and issue a timely written decision. Thank you very much for your arguments this morning. The court will be taking a brief 5-minute recess. We stand in recess.
All rise. The Court of Appeals, First Appellate District of Ohio is now in recess.
So nice meeting you. Take care. I'm sure I'll see you around.
Yeah, we've done some stuff together. Yeah. Traded. Yeah. She was sick as well. I think she was out. Yeah. Yeah. Just We're not submitting. Turn it over.
I don't know if that's possible, because you're going to law resisted at times, so like.
There's not been as many changes as I thought this one would be. Felt like it was a change. Justice Hill. Somewhere between 70 and 80%. At least the There's Russell. Charles is still there, but it's not. I think they're looking to be consistent. But it's a fun, I think it's a good idea.
True, I get to the time where you go, oh, yeah. Now, he's like with an 18-year-old, and, during the test, I guess,
I'm like, it's all the same people. Like I was talking about something. It's like, that's the same. Except Teeter. This is the same, like, this is not anyone, it's not really. Yeah. It's like, I was actually really surprised. I will. Yeah, I mean, it's been what, 4 months, like, it's not like, how much she do. That's my favorite. That's my favorite. No, it's bad. That's right. So feared. Because they can see they're all out there. So you're all like, yeah, exactly. And to be fair, she ran out something, No, exactly. It doesn't. No, you're correct. So, yeah.
You want to take your seats? All rise. The Court of Appeals, First Appellate District of Ohio is back in session. Please be seated.
All right, the third case on the docket this morning is C-24-0437, State of Ohio versus Sean Donovan.
Good morning.
Good morning. Would
May
you
I
like to
please-
reserve time for rebuttal?
My bad. 5 minutes.
Right?
If it may please the court. Mr. Cummings. Your honors, I think at the time Mr. Daniels at the top, or at the bottom of that hill off the cul-de-sac, turned and pointed that gun as a 2-time convicted felon, threatening, irrational, but pointed his gun towards Mr. Donovan. Mr. Donovan had a reasonable belief of the imminent harm, and at that point acted in self-defense. And the trial court, in this case, finder of fact, just misapplied the law concerning both duty of retreat as well as re-engagement and found that he didn't have the right to use self-defense. And
Mr. Gallagher, can you please give me your best argument why the Worth case doesn't apply here?
Oh, yeah, absolutely. Not apply. In fact, quite frankly, I think in a lot of ways it does. And let me, so Worth, you have a victim that was unarmed. Here we have a man that was unarmed.
But the defendant in Worth claimed that he believes that she was armed
got
based
that.
on her behavior.
I get that in terms of behavior, but here instead you have an act of violence, first by Mr. Daniels pistol whipping Mr. Donovan, threatening him with his life, and then pointing a gun at him. It's not a perception. It was an act that was caught by Mr. Donovan. He's told the trier of fact he did not shoot, point his gun at him again, until he was pointed at. Right after a threat of, the next time I see you, I'm going to kill you.
Well, so isn't that a future threat?
Pardon me? It is.
And
It's not the threat,
isn't it fair to think that he was leaving based on the video evidence?
No, because what is there is because after the threat, he turned, lifted his left arm that had the gun in it, and turned towards Mr. Donovan.
So you think that's demonstrated on the video?
Pardon me?
That's demonstrated on the video?
No, I think it's demonstrated through the credibility of Mr. Donovan. And what Mr. Daniels admitted, which was he did raise his arm and admitted that the gun was most likely in his left hand. And
So it's Donovan's testimony, it's the admission regarding the motions of the arms,
Right.
and then what about, it seems like there's this gap of time where Mr. Donovan has his weapon raised, and it seems like, when you watch the video, that the victim is walking away.
Okay.
What about that?
There's nothing wrong with that. That act itself is not illegal. This court has found so. That is not an illegal act. It's
Well,
not even an act of aggression.
at that point in time, though, couldn't a fact finder find that he should not have been in fear as the person is walking away?
Well, he could say as the person is walking away at that moment, but the problem is that was not the end of it. What Mr. Worthington corroborated is what Mr. Donovan heard and then saw. And Mr. Daniels himself corroborated that fact when he said that he thinks he waved him off. He knows the gun is in his left hand.
Well, when he says he waved him off,
Right,
if that's the admission,
okay.
that's a lot less than I pointed the weapon at the other person.
No problem, but it is also from the person, if the court remembers, it says, I'm a little blurry that day. I probably had the bag. I assumed the gun was in my hand. I probably just waved him off. And then had everything wrong that occurred in the initial confrontation, if the court remembers. So what you have is the fuzzy memory of Mr. Daniels, however, admitting that the gun was in his left hand, who denied making certain statements that we know Mr. Worthington heard, and Mr. Donovan, who was corroborated not by just Mr. Worthington, but also the detective who said Mr. Donovan's initial statement to him matched the video. So immediately afterwards, when Mr. Donovan talks to the police, he's clear, concise, and consistent with the video. Mr. Daniels is not. Mr. Daniels has actions occurring in the interaction between the two of them when he pistol whipped him over a dog with two kids there is not consistent with the video. He's not consistent with himself. And so I don't think that the court can at that point, but it's about not getting the facts wrong. It's about a misapplication of law. It's about saying that you don't have the right to engage in self-defense because you walked outside your house to see if a threat was gone while your dog and two young kids were out there. That you can't do that. That somehow that act is an act of vigilantism. And I would suggest to you that under Worth and under Butler and under Brooks and all the other cases, he's allowed to do that. And under Mitchell, he can do that. Under Mitchell, he's allowed to have a gun at his side. He's allowed to even step forward towards someone who's armed.
Does the fact that Mr. Daniels had a gun during the initial encounter but didn't use it to shoot at all affect whether there was a reasonable fear during the second part of the encounter?
Not necessarily, because now you have also another threat, an irrational threat, right? We've had an argument, a man has now come up to you and pistol whipped you because a dog is not on a leash. Right? not on a leash. And now says, next time I see you, I'm going to kill you. And doesn't walk away,
In the sequencing of
turns.
events,
I'm sorry?
in the sequencing of events,
Yes.
because the videos don't have, understandably,
Correct.
don't have audio, so I
Right.
want to make sure I understand exactly what happened when, from
Right.
your perspective. The initial encounter with the pistol whipping happens,
Correct.
and then the threat is made that I'm going to kill you next time.
That's, I would suggest, is after the break-in time or while Mr. Donovan is at the cul-de-sac and Mr. Daniels is further down the street.
Okay, so the threat comes after the initial physical
That's my understanding
encounter.
of it, right.
Okay, thank
He
you.
goes back in and gets his gun before
goes back in-
before he hears that threat.
Well, I think he had already had other threats, right? I think he had other threats.
The
and I don't-
threat that I'll kill you the next time I see you. You don't.
I didn't try the case, so I'm not sure, but I know there were at least some threats that were made in that initial confrontation, according to Mr. Donovan. But the threat, but he went outside, not, if the trial court in its finding, that I still think misapplied the law on this case, said that Mr. Donovan walked in dispassionate and then characterizes him as coming out as a vigilante. And I think those two are inconsistent. A vigilante goes out and starts shooting at somebody. A vigilante goes out and chases somebody down the street. A vigilante shoots 10 times like in one of the cases before you. And in this case, he's got his dog outside and two young kids outside, and he said, unimpeached, I went out there to make sure, one, the threat was done, and two, that people were safe. That's what he did. And he didn't re-engage him. He didn't get aggressive towards him. He didn't run after him. He didn't do like in Worth or in Butler, chase somebody down the street and shoot 10 times at a car, or in Worth after everything is over with. But Worth did say, which was that it was okay, that the issue about going out with a gun on your side is not the issue. The issue is about self-defense. What this trial court did was determine that that act of leaving your home to go in front of your home to see if the threat, the irrational threat, has left so that everyone is safe. And finding out that it hasn't left. It's mindering around down the street a bit, but still willing to point a gun at you, still willing to wave a gun at you or point a gun at you. We have this irrational man that's down the street who's got a gun. And I get that maybe you want someone to just call 911. That's fine, but it's not illegal to do what he did. You want someone to just stay in his house. That's fine, but it's not illegal to do what he did.
The coming outside part.
Correct.
With
But
the gun.
That's
Not
correct.
illegal.
Not illegal
We
at
can
all.
all agree with that. But then the perception of the victim, the amount of time that elapses as he comes outside.
Okay.
I mean, it seems like it's almost, the video is inconsistent with the feeling or the proof of fear that he was in a reasonable belief.
When he left the house?
At the point where no, not when he left the house, not when he's out there with the gun, at the point where they've engaged in their gunplay, and it appears after that gunplay, where the victim is behind the car, that the victim has decided, I'm going to give up on this,
Right.
and starts to walk away.
Right.
And then he walks away for some period of time,
Correct.
and then he says in his testimony something like, perhaps, maybe he waved him off. That's what he thought he was doing. But from Donovan's point of view, that was him pointing the gun at Donovan.
Correct.
But isn't the other point of view also equally acceptable to a finder of fact, that he wasn't pointing the gun? Based on the view of the video?
Because the problem is that you'd have to make a finding that's outside the video. So you're saying the thing that you can't see occurred.
Well,
But
the video, there's this long lapse of time as the victim appears to be walking away. And then maybe there's a split second. It seems to me like you're saying that Donovan made a split-second decision while the victim was walking away to fire at the moment when he raised his left hand.
I don't think that that's necessarily what's going on here when you read all Mr. Donovan's testimony. He's waiting to make sure that this man leaves. He went outside, told him to leave. It wasn't just saying, come back here and fight. I mean, we have these other cases where if you're inviting someone back to fight, if you're doing these things, you're being the aggressor. He's out there making sure that that threat leaves. The man is walking away, and I agree with you, but then makes a verbal threat and turns, according to Mr. Donovan, and points the gun.
And the verbal threat is immediately before the pointing of the gun.
Correct.
And you get that from Donovan's statement and from the other witness.
The neighbor. The neighbor heard that statement. Mr. Donovan doesn't shoot at him as he's walking away or just waving his hand. He says he shoots at him when he turns and points. And everything Mr. Donovan had done up until then, in that moment, was calm and confident. That doesn't mean he's not scared. That doesn't mean he's not apprehensive. That just means he's calm, as opposed to the irrational man who's out up on that street. And we can't accept his word for lots of different reasons. But the problem is this: the trial court, in looking at this, said that he lost his right to self-defense the moment he armed himself and went outside. So we're not making a determination about pointing a gun, because he said the trial court, in misapplying the law, has said he's already lost his right on self-defense by going outside and armed. And it's contrary to the holdings of all the cases that are in the brief.
So where is the trial court saying, where would you say the trial court says that exactly? Is that in the record when he's making his decision?
Yes, sir. It's in the written decision. The defendant was safe within the brick walls of his residence. He chose to re-engage and seek out the victim, who was then walking down the street. Criminal liability lies with the defendant, as he created the situation, giving rise. The defendant could well have avoided the danger, but rather retreated, armed himself, and then left his place of safety to confront. Those are all statements he made when saying that the defendant had lost his right to self-defense. And then there is no finding of fact as to why his belief was unreasonable, only a closing statement that the state proved beyond a reasonable doubt that the defendant did not have a reasonable belief of imminent harm, even though the only clear evidence in that case was from Mr. Donovan, who said that Mr. Daniels pointed a gun at him before shooting. You can't see on the video.
And those findings were with respect to entering the affray or being responsible for the affray.
Correct. And what this court has found in all the other cases, I mean, we talk about Mitchell, engaging with a gun at your side and even stepping forward towards the deceased in Mitchell was okay and permitted by law. You don't lose your right at self-defense at that point. You just don't.
So I want you to clarify one thing for me. So the fact that the trial court noted that Mr. Donovan went back in the house, armed himself, and came back, are you arguing that that goes to retreat? Are you, because rereading Worth, the issue was not that he had a duty to retreat and had a duty to stay in his house, but it went to who is at fault for the resulting situation.
Right.
So what do you think the trial court did here?
I think what the trial court did here was, it addressed retreat. It said, I don't have to deal with retreat because you really had no duty to retreat, but then said in that same line, right after saying you have no duty to retreat, but this is different because you went outside armed. The problem is that Worth speaks to the fact that it was not a problem for Worth to arm himself. What was a problem was the threat was completely over with an unarmed person, then being pursued. Mr. Donovan didn't do any pursuing. But the fact that the trier fact in this case stated straight up, you lost your right of self-defense the moment you left that place of safety, is the misapplication of the law.
Is it possible that the trial court said that because it didn't believe that he was leaving his house with a gun to protect the dog and the children?
Yes, I mean, I think it's clear that the court believed, without any evidence, that he was acting as a vigilante, called him such as so, that he went out as a vigilante.
Mm-hmm.
But I would suggest to you that the vigilante is someone who maybe exists in like Butler, right, which is the unarmed person in the car, you see that everything is over, is driving away. Butler testifies, I fired 2 in the air, but somehow we learned that there were 10 shots fired at the gun. I think that's a vigilante. Going outside and telling someone to leave who still hasn't completely left with the kid and the dogs out there is consistent with what he said he went out there to do. It's not consistent with someone who would pursue. If it's true that that was the gain of it, then you would have seen an aggressive run up the street or down the street, firing a gun to shoot, if that was the vigilante's thing. You wouldn't have seen this sort of back and forth that was started with Mr. Daniels first points at the gun after Mr. Donovan was outside. You wouldn't have seen that. You would have seen much more aggression out of him. Everything that Mr. Donovan
Gallagher,
did out there.
Unless my colleagues have other questions,
Oh,
you've far
I'm done?
exceeded your time. Thank you.
Well, thank you very much.
Good morning.
First of all, I just want to make the court aware that counsel went out of his way this morning to approach me and let me know that he would have no objection if I asked for a continuance because he knew that I had picked this case up this morning from my colleague. And I said, I don't think that's necessary, but I thought it was a very gracious offer, and I wanted to say I appreciate it and let the court know that was made. As far as the substance here, I understand the Ring video cameras tell the tale, and I acknowledge I have not seen those. However, I've read the transcripts, and it seems like just from Mr. Donovan's testimony alone, the trial court got it right here. He admits he could have stayed inside. He says he went back outside variously to make sure that the victim left or to make sure the dog was safe or the kids were safe. So right here, we've demonstrated two prongs that the state proved that he did not prove in self-defense. He did not have a subjective belief that he was in imminent danger. He didn't have an objective belief. And he didn't avoid the danger by staying inside.
Well, let me ask you a question on that. If indeed we were to find that he did not have a honest belief that he was in danger, could the fact that he was, that he stated that he wanted to protect these children and the dog, I mean, defense of others, how would that fit in?
Well, offhand, the state would say that it doesn't apply. I think that would have to have been pled and argued at the time, and I don't think it was here. Secondly, the circumstances of the encounter, as described by both men, do not indicate that anybody was threatening the children or the dog. So if that was ever a claim being made,
Well,
it was not supported.
Didn't the victim point his gun at the dog?
That's true. That's in there. But I really don't think that's what was going on here, and I don't think the trial court would have believed that he went out there to protect the dog. I read the decision of the trial court differently than my counsel. I think the trial court clearly, right off the bat on page 2, acknowledged that the victim was the aggressor. He says the victim engaged Donovan, the victim swung a gun at Donovan. So on page 3, the trial court's clearly saying that the victim was the initial aggressor here. I think this discussion that counsel and the court was having doesn't go to the aggression issue as much as it goes to the second and third prong, especially the third prong, which is where you have a duty to avoid the danger. And I think that's where the trial court was discussing the fact that, hey, once you're inside your house and you're safe, stay there. You're safe. You don't have to get a gun and go out and, survey the area.
Let's say, the assignment of error that has been raised here is that the trial court misinterpreted, the so-called standard ground law. And let's say for the sake of argument that we agree, that the trial court basically said there's a duty to retreat and there isn't a duty to retreat. What is the appropriate remedy in that circumstance if we were to go down that hypothetical logical path? Do we reverse the conviction and have a retrial or send it back for the trial court to reanalyze under the correct legal standard? I mean, what is the correct outcome if the trial court did in fact misapply self-defense law?
Well, I think if that's the finding, you'd reverse and send it back for a trial, or another trial, I believe. I don't think you have to go there here, though, because I don't think the trial court misapplied the law. I think all of this discussion about, at some point, it has to be reasonable and it has to be an honest belief. And if you really believe you're in danger and you're about to be bodily harmed, are you going to turn your back on the guy that you're afraid of? No. If I'm really afraid of my opposing counsel, he's going to shoot me or do something to me, am I going to turn my back on him and go into my house? What does that tell me? It tells me he didn't really have a belief that he was in imminent danger of bodily harm. He turned his back on the man he's afraid of. Nobody
Right,
knows
well,
that if
so,
you're truly
so
afraid.
if that's true, it seems like the argument is not so much about that. It's that when he comes outside, that Mr. Donovan is attempting, from Donovan's perspective, to make sure that the scene has been cleared and the threat to the street, the dog, the kids has left, right? And at the moment where he, the victim, raises his gun, that's the moment when Donovan had a reasonable fear and acted in self-defense. Not so much that when he went into the house and came back outside. It's at that moment when the victim again became the aggressor that it was reasonable to engage in self-defense.
Well, that's a good summary of Donovan's perspective, yes. I
mean, it's not so much,
understand it.
he was in a place of safety, and he came back outside.
Right.
And at the moment where he theoretically saw the gun come up in the left hand, if it was in fact pointed at him, then maybe it turned from I am clearing the scene to I'm in a reasonable fear of imminent harm and I must shoot.
Well,
That's at least one perception that a fact
That's
finder.
one perception, but I think to get there, you first have to work your way through the fact that, I think, first of all, the trial court never said that you lost your ability of self-defense as soon as you went outside with your gun. I don't find that in the record, I don't find that in the decision. So I don't know where that's coming from. The discussion is triggered by the fact that it looks like this is one of these cases where the defendant sought out, followed, pursued to re-engage very deliberately a threat that had walked down the street and was walking away. And I think the defendant admits that. Yeah, if he kept going that way, he'd be going away from me. That's actually in the record. He admits that. I think the problem is he just didn't walk outside on his porch and look around. He went into the street. He continued to pursue the perceived threat, which was no longer a threat. And I think that's where this house of cards falls down, and I think that's what the trial court was getting to. Unless the court has any further questions, I think it's pretty well covered in the brief.
Thank you.
Thank you.
In page 142, I think, of the transcript, when the court, in announcing its decision, said the defendant chose to re-engage, he blamed Mr. Donovan for starting the events and said he didn't have the right to self-defense by going back outside. I mean, that's what he found. He found that he was the aggressor by going outside there with the gun, and therefore didn't have his right to self-defense by going outside. That's just contrary.
And is it your perspective that as a result, the trial court didn't further analyze the elements of self-defense?
Correct, absolutely, because found that he didn't have the right, because he re-engaged, he created a situation, and the court said that as well, that he's the one that created a situation. He didn't. With all the case law from Brooks and Butler and Worth and everything else, that's not the case. I think I also cited a case, I know it's not from the first district, but I also gave you the case of Cumberlander, which talks about what re-engagement means. And it gives lots of different examples of what that means. It means a fighting stance. It means inviting someone to come to you and fight. It means all of those things. That didn't happen here with Mr. Donovan. Mr. Donovan walked out in his cul-de-sac. He didn't walk down the street. In his testimony, Mr. Donovan's from page 180 to 205, they go through the entire description of step by step. And he talks at times about Mr. Daniels walking towards him. He talks about not pointing his gun until Mr. Daniels first pointed. That's Mr. Donovan's actions out there are all prompted by actions that Mr. Daniels took out there. He's allowed to go outside with a gun. You've all decided, this court has decided that in lots of other cases, that there's nothing wrong with doing that. What he cannot do is then begin to create the situation. He didn't threaten to shoot Mr. Daniels. He asked him to leave. He didn't ask him to come back and fight. He told him to leave. But the trial court misapplied the law as it looked at it and already decided he was never going to have to, he couldn't engage in self-defense after he went outside. And I respect that that's incorrect. I think what the remedy would be is to sending it back with the correct and asking, saying, self-defense still applies, you don't lose that right upon walking out. Now what do you think about the evidence? Or you can go to my second issue if you choose, and just grant him a new trial and say the manifest weight, because that's the remedy with the manifest weight. But you have a de novo review in terms of it. You don't accept the trial court's findings. You don't have to accept any of those findings when looking at this, because it is a de novo review. It's not an abuse of discretion. If I was on abuse of discretion, I'd have a really, really tough time with all of you. I get that, because you'd be asking me about where that occurred. But this is not that. This is a de novo review by the court on this type of error. And I think, upon looking at it, this trial court declared that he was a vigilante by going outside, and this can't be.
Was the trial court even required to explain all of this, or could it have just reached its verdict?
I guess it could have just reached its verdict, and we'd be left with I'd be talking about manifest weight, but because it did, right, it'd be no different than if for some reason the jury were given interrogatories, because we wanted to know how they looked at self-defense, and if both sides were going to go there and say, ask the following questions, right? Did the defendant re-engage, and how? And if the jury came back and said, we determined the defendant by being armed and going outside was the aggressor, and therefore started this whole thing, is responsible for all of it, you'd have some findings to deal with. The trial court did what it did, and that's why, I mean, I get it. It would be obviously easier for your review. I wouldn't have that error probably without that written decision. But the court stated its written decision, and in doing so, that's why we don't have these issues very often. We really don't have misapplications of law by a finder of fact very often, for some of those very reasons. One is I don't think the mistake happens that often, but this is a relatively newer law, and I just think that the court just got it wrong in its misapplication. But I also think against the manifest weight exists here too. When you look at that entire thing, the only credible evidence is Mr. Daniels pointed his gun at Mr. Donovan, who shot one time in self-defense, didn't flee, stuck around, told the police a story that was determined to be consistent with that video, and never was impeached about it at the trial court. If you have no other questions, I think whether I've used my time or not, I've probably used all my time.
Thank you very much.
Thank you for your consideration.
We will take the matter under submission and issue a timely written decision. Thank you for your arguments this morning. Our final case on the docket is C-240461, State versus Thomas.
Hello.
Good morning. Would you like to reserve time for rebuttal?
I would. I'd like to reserve 4 minutes.
You may start when you're ready.
I'd like to start with the ineffective assistance claim for failure to file a Bruin-based motion to dismiss. I think at the onset, this is one of those gatekeeper type issues that I think would cause concern, that if Court of Appeals finds ineffective assistance and failure to file a Bruin motion, that's going to get some attention, right? And so that's why I think this is such an important issue. And I think the first issue is, what is the standard, right? We all know what the ineffective assistance of counsel standard is. There has to be an error and it has to prejudice the defendant. But what does that look like in this context where there's a failure to file a motion to dismiss, right? Because I think the state points to Johnson, which says it's not ineffective to maneuver within existing case law, right? You don't have to present some new issue or even an issue that's already been rejected by the courts above you. Except Bruin wiped the slate clean, right? All Ohio existing case law and even federal case law pre-Bruin that had this means and scrutiny that looked at the state's interest, that's all gone, right? So I think that standard doesn't work here. I think the standard in Garrett does, which is, let's look at the case, right? Is this a little motion to dismiss in the context of the entire case, or is it something that's outcome determinative, right? And it is here. And I think finding ineffective assistance in this case is really, really narrow. I think we're going to have a no contest plea or a trial. I think it matters, the timing.
I think there's a big difference between whether somebody chose to file a motion to dismiss after Bruin, but before Rahimi. Because I don't think it was very clear to everybody, or even most people after Bruin, about whether that Second Amendment first prong was dependent on the law-abiding citizen language. I would have argued that we all knew from Bruin that it wasn't so limited, but I can see where there'd be some confusion, right? Then Rahimi comes out, and the news coverage of the defendant Rahimi was that he was like a Yosemite Sam character. This is clearly not somebody who's a law-abiding citizen. And still, the Supreme Court goes through that second prong and analyzes the history. And now we have this language of a particularized finding of dangerousness, right? So now we're all as defense attorneys trying to think through, well,
But Rahimi did not prevail in his Second Amendment claim.
right.
So how would Rahimi have given guidance to file a Second Amendment motion in this case?
I think Rahimi strengthened the argument that the first prong of the Bruin test, whether the Second Amendment is limited to law-abiding citizens, I think it answered that question even more affirmatively than Bruin did. So I don't think Rahimi says.
So it eliminated a potential option to lose the motion to dismiss.
Right, it did. And then I think it does matter who the specific trial judge is. I think as a defense attorney, as you're talking to your client, you're trying to figure out how to help them maneuver through closure of their case. I think you're in a very
Is that
different situation.
dispositive, though? Because doesn't the ineffective assistance case law require us to look at the status of the appellate landscape at the time that the motion to dismiss would have been filed? Isn't that what governs what would have been reasonable from a performance standpoint?
I think in most cases, yes, but I don't think Bruin is like most cases. Like, it just was a sea change. So now we don't have appellate cases within Ohio that definitively answer that question post-Bruin. So I think we are in this weird, unusual situation where we don't have appellate decisions. I think it makes sense to look at the trial court decisions, right? And then I think when we think through one of the other primary arguments on ineffective assistance of counsel is, well, what's the strategy decision, right? We're going to give a lot of deference to trial attorneys when there's a strategy decision. Well, what is it here, right? There's no plea agreement to accept.
Well, on this record, we have no idea. We'd just be speculating, right?
Right. So we don't have something in here that we can point to, well, he didn't do the motion to dismiss because here's some benefit he's securing for his client. I think it matters here that all of his charges are firearm charges, right? It'd be different if you have a firearm charge with a drug trafficking, right? Because now it's not, the motion to dismiss doesn't take care of all of the counts, right? And then there's potentially a harmless error standard depending on which of the charged conduct results in a bigger sentence.
In order to rule in your favor on the ineffective assistance claim, do we have to find that Thomas had a probability of prevailing on the motion to dismiss?
I think so. Based on the standard I've put forth from this court, yes, I think there has to be a probability.
So we have to reach the underlying Second Amendment claims.
I think this court could say that there's a probability that he may have succeeded on a facial or an as-applied challenge and remand it back for more of a factual development as to whether or not he is deemed to be dangerous enough to be disarmed presumptively permanently.
So I just want to clarify something. In your brief, you, your characterization of the ineffective assistance of counsel standard, you say possibility, and you say that there was a possibility, motions to dismiss possibly may have been granted, rather than probability, which I believe probability, and you just said that that is the correct standard, correct?
Thank you for asking that question. The case I cited to, which is State v. Garrett, does say the possibility. So I misspoke when I said probability. I think this Garrett standard is possibility. But again, I think that's where all these facts come in, is the trial court had already granted 3 motions to dismiss based on Bruin. All of his charges are firearm charges. the conviction causing the disability is a 2016 drug possession, so it's not trafficking, it's not a crime of violence, it's not something that uses a firearm. So that's why I think all these facts matter.
Let me get back to the possibility versus probability for just a second. So you cite Garrett, which is a 1991 case. Did you find any other case law using the word possibility rather than probability?
I did not, and to be candid with the court, the Garrett case doesn't cite to any case decisions for that conclusion.
Okay, so
which is why I
this
think
court has always held that there needs to be a reasonable probability,
Okay.
correct?
I have not missed, I apologize, then I've missed those cases.
Okay, thank you.
And if the court has no further questions.
Can you go back to, are you going to argue your other assignment of error?
If this court has questions, I will answer them.
Okay, so was there any argument below that the change in the law, the marijuana law, both in the city or the state or whatever, that the change in the law means that a search based on the smell of marijuana is not justified anymore?
I don't believe that came up at
Okay,
the lower court
so is it
level.
waived, except for plain error? I mean, how are we supposed to deal with that since it was not argued below?
I think it's certainly a trickier question on plain error. And it still comes down to, like, once they've determined that the BB gun is a BB gun, right? He said it was a BB gun when he made his furtive motion, that he was gonna get the cartridges to prove that it was a BB gun. They know it's a BB gun. We have this smell of marijuana in a city where it's been decriminalized, right? So is this.
But again, that was not argued below.
Right.
Okay, go on.
But I think when we're looking at the full circumstances, which I think this court can consider, we have this smell of marijuana, we have a BB gun, and we have the expired text. So is that enough for that officer?
Doesn't case law support the idea, because he had been removed from the car, and I do not understand his motion either below or his brief here to be challenging his removal from the car. Isn't there case law that says that before a person is put back into a car, that officers can conduct a protective sweep of that car to ensure that the environment is safe before they allow the person to get back in the vehicle?
Yes, there is case law that says that. But again, I think when we look at the facts and circumstances, and you're not limited to what the officers articulated either, but I think it matters in this case.
And so why wouldn't that provide that just simple landscape? He's been removed from the car, he's going to get back in the car. Why wouldn't that provide justification for the search of the vehicle?
I still think they have to have concern for ongoing officer safety, and I think that concern for officer safety stopped once they knew it was a BB gun.
So when did that happen? It's the BB gun discovery?
So they had, the one officer saw it, and you can see it pretty clear in the video. It looks like a gun.
In the
So-
car, in the vehicle?
In the back seat of the vehicle. So they have him out, they have him handcuffed, they have him, from what I can recall, like a good 10 yards away from the vehicle. He's now handcuffed, they're patting him down. And at this point, the officer who's remaining in front of the car is standing there, and he says, I didn't go through the threshold. Like, it becomes, at least from my reading of the transcript, very important to him that he has stopped, and he has not gone through this car. He is not searching, he's just waiting. They verify that it's a BB gun.
How did they verify?
They check it. They said that they looked at it. I'm not a firearms person, so I have no idea, but they
So
say that they did.
they're already in the car?
They,
I mean, once they're already in the car,
right.
even though they find that it's a BB gun, they can continue to search, right? It's not like they have to stop their search because they've discovered one piece of contraband.
Right.
Or possible contraband.
They don't have to stop, but they did.
Does that matter?
I think it's part of the facts and circumstances. I think it's something this court can consider is, did they have to stop? Not necessarily, but they did.
So are we supposed to look at this from the perspective of, okay, they chose to stop, so therefore it's done? Or do we look at, was there probable cause to search the car? Or was there officer safety issues that justified a search of the car? How are we supposed to look at this?
I think you guys can look at it as, was there probable cause to search the car? I mean, I don't think the question is hard. The question becomes, at least for me, is like, well, if they had probable cause to start, does that mean they can always do it no matter what they learn, no matter what they see, no matter what happens? Once they have an officer safety concern, is there anything that brings that to a stop? And I think here, there is something that brings it to a stop. They get them out, they check that it's a BB gun, now we just have expired tags and burnt marijuana. So I don't think there's an ongoing officer safety concern. Now, had they continued the search and not stopped, we'd be in a different set of facts, but they did stop.
Well, counsel, I mean, going back to my earlier question, that in theory, they were going to be putting him back into the car, and the car was fairly messy, for lack of a better description. I mean, there were personal belongings. There was like this large plastic box in the back and things on the front seat, and they hadn't checked any of that. And case law says that it is reasonable from an officer safety standpoint to ensure that the car is weapon-free before someone is released back into the car. So wouldn't the condition of the car itself justify checking it before he's put back in?
I don't think in these facts, because when I think about that question in the broader context, like every time the police pull somebody over and get them out of the car, if they happen to be a messy person, are they subject to searches for weapons, right? Because I think that kind of finding is that broad. If they pull somebody over and they, even if it's a speeding ticket and they don't get them out but the car's messy, do they get to stop and clean it every time? I don't think so, right? So I still think they have to have this articulable officer safety concern issue. They did when they saw the BB gun in the back seat. They didn't know it was a BB gun at the time. Once they find it's a BB gun, we're done.
And so you think that dispelled whatever notion they might have had, that dispelled it?
I do.
All right, your time has expired. Thank you.
Thank you, and may it please the court and opposing counsel. If I may, I'd like to start with the second assignment of error, the same way that opposing counsel did. And I want to make a distinction between the Strickland elements as to what is actually a question here. There's two prongs that I think are at issue. The first one being whether or not there was actually a violating of a duty, which I think goes to the McNeil standards about maneuvering within the existing law. If the court finds that there has been no violation of existing duty, you do not have to get to the question of the possibility or probability, which deals with the prejudice that has to be established. Based on the Strickland standards, there has to be both a violation of the duty from the attorney, and there has to be prejudice.
Well, what about the argument that Bruen and Rahimi were sort of these seismic shifts, you know, in Second Amendment case law, and that these charges are all gun-based, and that any reasonable lawyer would have filed a motion to dismiss, given that legal landscape?
At least to the first prong. I mean, it's been a seismic shift in my life, certainly, as to Bruen.
Yes.
But at
Can
least
relate.
at least reading the plain words of Bruen, I mean, they say pretty specifically, we are not upending the law. We're essentially just reapplying Heller, DCV Heller, and just applying the first step of it. So I would disagree that all of with the implication that Bruen completely has wiped out every single Second Amendment jurisprudence that has existed. But for the purposes of whether or not there's been a violation of a duty, the McNeil case from the Ohio Supreme Court tells us to look at whether or not the defense attorney at the time is maneuvering within the existing law and declining to present, their words, untested or rejected legal theories is not a violation of that duty. I mean, I understand that now the burden is on the state when someone properly raises a constitutional Second Amendment challenge, but there is, I think there's almost been a concession here that the legal theory that would have relied on these motions to dismiss was untested in Ohio at the time. There were a few cases that have gone through, and I think one case was sent back down by the Ohio Supreme Court, but certainly there was not any legal theory suggesting definitively that this is something that he could have succeeded on. And because it was untested, and any other legal theory, including Rahimi, would have rejected this argument, I don't think that we can say that the defense attorney violated any duty to his client. I mean, I'm unable to imagine a test that this court can develop that would say that anytime essentially anytime a new U.S. Supreme Court case comes out, a defense attorney is ineffective when they fail to explore that challenge at all under any circumstances. I mean, it seems like that is what this court would have to espouse in order to find it.
If we look at the Supreme Court's decision,
Mm-hmm.
at least in Bruin and Rahimi, which are the two landmark cases that are being suggested that trial counsel should have followed, Bruin was a civil case. It prevailed.
Right.
Rahimi was a criminal case. It failed.
Correct.
So is there anything we can glean from that in terms of what trial counsel should have done?
I think, I mean, obviously, it's incumbent upon a defense attorney to examine the circumstances of their case as the law develops. But in terms of filing a motion to dismiss, I think a defense attorney at the time would have had to have understood and examined the fact that the circumstances for the underlying disqualification and Ohio's scheme for firearm regulation is different than the federal scheme. The burden on Mr. Thomas was different. I think underlying all of this, though, at least in what I would recognize without the benefit of maybe cases that came out in the future, at the time that this plea was entered into, the first thing I would be looking at, and maybe that's just me personally, is the fact that in Bruin they said that it's not upsetting the longstanding jurisprudence on barring felons from possessing firearms. I mean, that's the first thing that I would recognize. And to hear where his firearm disability is based on a felony conviction, I don't think there's anything in Rahimi or Bruin to suggest to the prudent defense attorney that he would have had to have filed something like this. I think everything would point to, at the very least at the time, that he would have been unsuccessful. But the standard is not whether or not he would have been successful. At least for that first prong, it's just whether or not he's maneuvering within the existing law, and at the time he was.
And let's say that we find that, just for the sake of argument, that the attorney was deficient, and we get to the impact and the prejudice that that mistake would have caused.
Right.
Is it your position that we have to decide what we ultimately would have decided with that motion?
I don't think it's possible for this court to do so. I mean, if we're talking about determining the probability of success, obviously, and this is I'll submit this is a strange case because the record would have had to have been developed by the state, and there would have had to have been it's impossible for me to understand what those specific challenges were, whether they are applied or whether or not they're facial. And that record is just not before this court, so I don't think this court is able to.
So are you, so if this were a viable claim, or it seems like you're suggesting that it should be a post-conviction claim rather than a direct appeal claim.
I think so.
Okay.
I think my point is that at least for this challenge before this court, it's maybe I'm happy to step back and finally say the burden is not on the state for a Bruin question, but at least for the ineffective assistance of counsel claim here, they have to demonstrate a probability of success, not just now, but at the time that the defense attorney made this decision, and they cannot do so. And so I don't think they're able to establish that probability.
Is it
of
enough to
success.
say that this particular trial court judge was granting some of these motions? Is that helpful in any way?
I don't think it is, and my understanding of the decisions granted by that trial court were for other different scenarios, for different factual scenarios, different disabilities, different charges under different circumstances. Certainly, I don't think this court would put out a rule that said that in determining ineffective assistance of counsel, we have to examine the record of every common pleas, this common pleas judge versus that one. I mean, all of the judges are presumed to be following the law and making decisions in line with the facts of those cases. So I don't think just the fact that the judge had granted a Bruin dismissal on a different case with a different set of circumstances has any bearing on this case. And if it does have a bearing, it's incumbent upon the appellant to establish that, which I don't think that they have. If I can reach the question, unless the court has anything more about the second assignment of error. There was a question posed by, I believe, Judge Bach about what is at issue here. Is it public safety or is it probable cause? The court below found both. In her decision, she noted that she agreed with the state that the continued search, which was her language, was justified both by officer safety and probable cause. To the extent that it was not argued below that the I guess, more is no longer good law, where there has been some sort of legalization of marijuana. I do believe that that issue has been waived, or at the very least, I don't believe that it can survive a plain error proposition. But I think the court was right in determining that that continued search was appropriate for public safety or for probable cause. Speaking directly to public safety, I want to make something clear, and I know, Judge Kinsley, you had brought it up. The law does suggest that when someone is being removed, if, assuming that they're going to be put back into their car, an officer is allowed to search any areas where he might have access to a weapon. And so even in that sense, the officers would have been permitted to search under I believe it was a jacket or something, where the firearm was located in the passenger seat. But specifically, what the officers said, both on the scene and speaking directly to the pellet gun or the BB gun argument that the fear of the officers had dissipated, what the officers said both at the motion to suppress and on the scene was that their concern was not based solely on that BB gun. The officers approached, they asked the defendant if he had any firearms in the vehicle. He said no. One of the officers spied what was, I think has been conceded, what appeared to be a firearm in the back seat. When the officers asked the defendant about the firearm in the back seat, he responded by reaching over, not to the back seat where the firearm was located, but over towards the passenger seat. They stopped him immediately, and as they're taking him out of the car and handcuffing him, they asked what he was doing. He said, I was reaching to get the cartridges or something. But I think what in the officer says, I think it was Officer Gunn who said on the scene, well, you're reaching for something in the passenger seat. That is I think, not only a reasonable but an articulated reason for searching. Their fear had not been solely dissipated by the fact that they had removed and fired, removed the BB gun and confirmed it was a BB gun. They still had to assuage their fears about what was in the passenger seat that he was reaching for.
And in fact, when they ultimately found the gun, didn't they say this is what he was reaching for?
I believe it was, I don't know what it was
Something like
exactly
that.
said, but they made reference to it. I think it might have been the pronoun and making reference to the firearm. And I think at that point, he had said that he had a firearm in the car before they had found it. So at least as to, it's my understanding, at least from my reading of the briefing and also the argument below, as it goes to probable cause, I think it was conceded. Frankly, my understanding of the briefing of opposing counsel on this matter is that it was conceded that smell alone could stand to be probable cause to search the vehicle. So I don't think we need to, I think under either of those prongs for the purposes of searching, that firearm was found under the proper channels under the Fourth
So
Amendment.
Moore is still good law.
At least,
Was it Moore or Morris? Moore.
Moore Morris. I mean, either way. I don't want to say that it's good law because that's not the question. I think that's a much deeper
Fair.
question. But at least for the purposes of this case, I believe that the application of Moore is appropriate here. I mean, I think the officers had probable cause to search under the automobile exception because they smelled marijuana. There's additional factors that I think we could rely on, and I make references to those. There's shake, he's smoking something when they walk up. So I'm hesitant to say that it was marijuana alone. Regardless, the smell of marijuana alone. But regardless, I do think that we had enough to establish probable cause that a crime was being committed here. In addition to, I think the officers had the public safety exception for which they were permitted to do a reasonable search of areas that could possess a firearm. And the Ohio Supreme Court has said that the state is not limited to put forth only one exception for, they can explore multiple avenues for justifying a warrantless search. Let me just make sure I'm not missing anything. This court did order briefing about the impact of the Thacker and Brown case. It's the state's position that not only would the state say that they're inapplicable here because they reach different issues, but where Strickland v. Washington requires an examination of the issues at the time of the defense attorney is making the decisions, obviously would not have access to those, and so should not be considered, at least for the purposes of determining that either that first or second prong of ineffective assistance of counsel. If there's no other questions, thank you.
Thank you.
Just a few brief points. The state mentioned a comment that I think was in Bruin, but I think was in a concurrence, about how Bruin didn't change longstanding prohibitions, maybe such as this one. I think that's in a Kavanaugh concurrence. So as a defense attorney, that's a big deal, that a sentence like that only ends up in a concurrence and not in the main opinion. I do want to touch briefly on the marijuana issue, only because I think there's a brief issue that we raised where more requires training and experience. And while I think there is testimony in the record that the officers encounter marijuana often and they smell it often, I don't think there's any facts about any training that they have. So I just want to mention that to the court.
So the fact that I believe the officer testified that he encounters it multiple times every day at work, wouldn't that kind of be on-the-job training at least?
I don't think so, because then you could argue that people who live in various communities where smoking marijuana on the corner is common, do they now have training to identify marijuana just because they encounter it regularly? I think it's...
Okay, thank you.
And then lastly, the statement about the firearm, Mr. Thomas did say there's an additional firearm in the vehicle after they'd already found and located the BB gun. But that happened when they were asking him incessantly before he was Mirandized if there was anything else in the vehicle. He admits it, the officer then searches, they then read him his Miranda rights.
And I want to clarify your Miranda argument. You're not making an argument that the denial of the Miranda piece of the motion to suppress prejudiced his guilty plea, or his no contest plea, like it negatively influenced his plea decision in some way. You're arguing, as I understand it, that the denial of that piece of the motion to suppress influenced the rest of the motion to suppress because his statement influenced the search. Am I understanding that correctly?
Yes.
Okay,
Yes.
thank you.
Yes. If there are no further questions, that's it.
All right,
you.
thank you very much. We will take the matter under submission and issue a timely decision. Thank you both for your arguments this morning. Have a good rest of your afternoon. Thank you. The court's in recess.
All rise. The Court of Appeals, First Appellate District of Ohio is now adjourned.